Welcome back to another J. Harris Academy Police Training Roll Call. I'm Joey Sperlazza. Today we're going to look at plain view and examine this new case, State versus Valerio-Guzman. This is a New Jersey Appellate unpublished opinion decided on April 17th, 2025. When we evaluate this through the lens of plain view, we have to look back to our previous rulings, which is State versus Brazil, which is a Supreme Court case from 1983. For plain view to be valid, officers have to lawfully be in the viewing area. The officer had to discover that evidence inadvertently. Inadvertently meaning that we didn't go into that area for the purpose of uncovering evidence. We were there for another lawful reason. And third, it must be immediately apparent that whatever it is that we're seizing is contraband. We can't manipulate that object to determine if it's contraband. It has to be immediately recognized as being contraband. So let's jump into this case, State versus Valerio-Guzman. Irvington PD responded to a shooting. They found two female victims. The witness identified the shooter, and the defendant was sitting alone on the front steps to 6 Berkeley Terrace. The exterior door immediately to the left of the defendant was fully open. The defendant complied, was handcuffed, and arrested. 6 Berkeley Terrace has 4 apartments with 2 front exterior doors. Each exterior door leads to a foyer, which gives access to 2 separate apartments. As the officers lifted the defendant from the ground after his arrest, Officer Gene Simon kind of looked up through the open exterior door into the empty illuminated foyer and saw a black and silver handgun on the radiator. He reported this observation, and the gun was seized by the Essex County Prosecutor's Office. The defendant argues that Officer Gene Simon's observation of the handgun in plain view while arresting the defendant did not provide a sufficient basis for the prosecutor's office to enter the building foyer and seize the handgun. The defendant's arrest in the courtyard gave Gene Simon the lawful opportunity to make the immediate observation of the handgun on the radiator in the foyer through the open exterior door. Based on witness identification, Gene Simon had probable cause to believe that the defendant was the shooter, and he used that handgun based on its proximity to the courtyard. The officer's conduct was reasonable and objective, and he was not required to close his eyes to suspicious evidence in plain view, when it's immediately apparent that the handgun was evidence related to the shooting. The search and seizure of the handgun met the plain view exception to the warrant requirement. The court next addressed the defendant's argument that the potentially shared foyer is the defendant's home and therefore is a constitutionally protected area. If it was the defendant's home, the defendant argues that the state was required to present evidence that the door to the foyer was routinely left unlocked or that the public routinely entered the common areas. In New Jersey, it is well established that a common hallway or area in a multiple unit apartment building is not within the zone of privacy protected by the 4th Amendment or the New Jersey Constitution. In his argument, the defendant relied upon State versus Williams and State versus Melody. So the court distinguished this situation between State versus Williams and State versus Melody. In State versus Williams, it was a boarding house or a rooming house. The living situation is distinctly different from that of an apartment building. In State versus Melody, an attached garage is afforded the same privacy protection as the rest of the home. It is part of the home itself, if not the curtilage. So that is definitely constitutionally protected. Here, the handgun was seized in a foyer, the common area of the apartment building, and visible from a wide open door. The foyer was an open space shared by residents, guests, and delivery persons. It was more akin to the common hallway of an apartment building, which belies the defendant's contention that the foyers constituted part of his home in which he had a legitimate expectation of privacy. The defendant did not have a reasonable expectation of privacy in the foyer. The prosecutor's office entry into the foyer was permissible. The trial court properly denied the defendant's motion to suppress. In this case, the entry was proper, evidence admitted, conviction upheld. One thing that's worth remembering for all of the officers on the street, if the delivery guys can go there, DoorDash, Amazon, the mailman, etc., if they can go there, we can go there. If not, it is a constitutionally protected area. Always err on the side of caution, as we always say. However, remembering, in this case also, we're looking at a handgun. What would have happened if we didn't go in there? We have occupied apartments upstairs. Are there children that would have had access to that handgun? There's also the public safety exception, which wasn't necessarily examined in this case, but if I see a plain view that there's a handgun in an area where a child could potentially get it, that to me is just common sense that you would want to seize that handgun for, at the very least, safekeeping, if not for evidentiary values. So stay safe, subscribe for more, leave comments below if you have any questions on this case or any others.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free, only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.